All right, everybody. This is brother Tatasha, man. Here you more. You can just call me George if that's a little bit too difficult to say. Um, yeah, I haven't made a video in a long time for the Golden Moor Legal Services channel, but I'm working on a case not only for myself but another client, and he actually let me give permission to share his paperwork. We'll look at his paperwork a little later. I want to talk about the case that I'm going through. If you've been following my story, about in 2016 in San Diego County, I was actually sued for child support by my baby's mother. And I went through Amen Osiris at the time because attorneys will not help you, first of all, with child support. They will not help you. They have a judicial conduct to the state. Their judicial conduct code, their number one allegiance is to the state. Even though you pay them, it's not to you, right? Let me make sure I'm being heard here. Okay, yeah, I am being heard. Okay, so it's to the state, brothers and sisters, not you, right? Okay, first, and then second, I went Tom and Osiris because I was just like you guys. I was panicked. I was scared. There's people trying to sue me for like 1,300 a month. This is when I was working in IT at Hewlett Packard, and I was scared. So that's why I tried to reach out to an attorney. Didn't help me, and then I just started doing research on YouTube, and I found Amen Osiris. Now, the good thing about Amen Osiris is if you don't know nothing about the law, you're panicked, you're out of your mind, go to him. He can get you started. Can get you started. Now, my criticism about Amen Osiris is he doesn't read well. He doesn't understand what he's reading. He doesn't know how to use it, right? When I was going through my case with child support, they tried to garnish me. First of all, they didn't mail me because they knew I wanted to fight it. So it's called sewer service, y'all, where they said that they mail you. They even got paperwork to prove it, but they don't have a tracking number or nothing, right? They don't have any of that. So if they know you're going to fight, they're going to lie about it in court. Because remember, Title 4D is not a court of record. So whatever's said in court, it don't matter. It's like you didn't say anything. And the problem that I have with a lot of my students, right, is that they go to court and they don't file anything. So when you go to appeal, you're almost guaranteed to lose because the the court and the commissioner, the judge surrogate, they're filing their paperwork, making you look very bad. Now you have the right to file your own paperwork in legal opposition to what they're saying, but you guys aren't doing it, right? So then you come to me and I have to educate you on how to write your own affidavit and what you should put in, who's involved, days you got there, and get that stamp by the court. So when you go to appellate court, the appellate court is going to look at the lower court records and see your argument. Now you can fight these people, right? And then, so that I figured all that in 2016. But then Amen Osiris's paperwork, he says, "Oh, we'll take it federal." This is the scam part. This is the scam part of Amen Osiris. Take it to federal court. Then he sells you more paperwork, but the paperwork only states what the law is, right? So if you turn in this academic paper, all he did was copy and paste it from the internet anyway. So if you take that and you say, "Hey, I want to file this case into the federal court," the judge is going to look at it like, "Well, you ain't telling me anything. You didn't tell me when you went to court, what was said, what did you bear witness to, what day this was on, what's the court docket number, what rule or civil rule did they violate, how did they violate your constitutional rules, how did they violate procedure." Almid Osiris don't do nothing about that. Either he's an agent, I hate to say, he's an agent, or he simply just doesn't understand the law, and he calls himself the God of Law. I'm more of a God of Law than Amen Osiris is, and we can have a debate about that, right? He knows because, well, he's ran through so many people, and he still looks like he's still broke. That he's been doing it for such a long time. It's more like a multi-marketing agency. You come in and you go around in this whirlwind, where he says this. He's been saying the same thing for over 10 years, guys. Right? So if you don't know anything, he could help you. But since as soon as you get your feet wet, you start learning, you'll see the errors in his ways. Then it's better just to do your own research. So this case has been going on for more than 10 years, right? Now I moved to Arizona, right? This is not why I moved to Arizona. I moved to Arizona because of business and investing and things like that. But I've always kept abreast upon child support law, the new techniques that these states are using to get people on child support. And technically, prima facie, I was still on child support, but illegally though, illegally. So, I got my own trucking business. So I didn't have to worry about getting garnished. But these people are reaching across state lines now to get me, which gives the federal court jurisdiction. And I'm being harassed, because the judge never looked at my case. So when I appealed my case in California, the justice in California was adjudicating on the bench. They were making arguments I never made in lower court, and arguments that the child support agency even never made on the lower court. So they kicked it back down to the trial court to finish it, but kicking it down to the trial court with a commissioner or a judge surrogate, there's still no decision made, because I never signed a D-204 form, which would give the commissioner the power to act as a judge. So she adjudicated the case without having the power to do so. So the decision is void ab initio, right? And so I'm suing this person. Her name is Penny K. McLaughlin. She's actually a judge now in San Diego County, and the Child Support Department. The San Diego Department of Child Support, right? So I'm suing two parties. Now they put in a this is the case number. You can look it up. It's in the federal case docket on Pacer. You can just put in Google, place this in. You'll see all the docket sheet. And they put in a motion to dismiss. Of course, they try to use res judicata and the Rooker-Feldman doctrine, right? Which I already knew that they were going to do. So as soon as they filed their motion to dismiss, I filed an opposition to defendant's motion to dismiss. So this is why I'm explaining. I titled it appropriately, right? Now, I didn't know you're not supposed to put all the names in capital letters, and I'm not a sovereign citizen. I'm just trying to go by the court rules. So you're actually just supposed to use the capital letters. There's some weird English stuff. In Old English, they didn't have capital letters. So even in your opposition, I put a table of contents here, and I put a table of authorities. Now, if you write enough affidavits, like I have for myself, and as examples for our students, that you'll find out that the judges want to see this, and in some instances, this will help you. In some instances, in some state courts, they won't even take your paperwork if it's not in this form, right? So it's pretty easy through Microsoft Word if you learned it. So what am I arguing here? We're going to go through this whole thing because it's only like 8 pages. What am I arguing here? What rules am I using? What case laws am I using to have a legal argument to so the judge can see this case truthfully and not through the eyes of the child support? Child support, they lie all day long. They lie all day long, guys. They lie, right? And so actually, this is an opposition to directly to just the DCSS, Department of Child Support Services, because Penny K. McLaughlin never replied, guys. She never replied. So I had to put in the application for default, and then the clerk put her in default. So I think I have to push for summary judgment next, but I'm not sure. I got to do some more research. So let's click here and go to the introduction. All right. So introduction, plaintiff George Smith respectfully submits this opposition to defendant's motion to dismiss for the reasons stated below. Defendant's motion should be denied. I'm now talking to defendant is the DCSS, should be denied because plaintiff, hold on, did something just happen to my recording? Okay. Defendant's motion should be denied because plaintiff has stated valid legal claims upon which relief can be granted and defendant relies on a void state order. So I'm saying that because they're trying to say that this was actually decided upon in the state court. And I'm saying that no, a commissioner cannot have a legal ruling in a state court simply because she violated procedure, right? And another point I want to make is when Amin Osiris is giving you paperwork to go into the federal court usually motions to dismiss your case because plaintiff did not state claim on which the court can grant relief. So they don't know what you're asking for, and they don't even know what happened. So you're going to lose every time. Okay. Standard of review under Rule 12b-6. Under Ninth Circuit law, Federal Rules of Civil Procedure 12b-6, motion is evaluated by assuming all factual allegations in the complaint are true and construing them in the light most favorable to the non-moving party. A complaint must state a plausible claim for relief, requiring sufficient factual content for the court to infer liability. So what I'm saying is, what they're saying is that when I make the complaint, I get the case started, the court's going to look at it assuming that what I'm saying is true, right? And looking at it and understanding it to be in my favor, right? Because I'm the non-moving party. They're trying to motion for dismissal. I'm just making the complaint, right? The standard requires accepting all factual allegations as true, and for pro se litigants, which is myself, applying a liberal construction to the pleading. Dismissal is warranted only when the complaint fails to state a valid legal theory or lacks sufficient facts, while pro se complaints are held to a less stringent standard. See dismissal, so they can motion on their own dismissal when the complaint fails to state a valid legal theory and lacks sufficient facts. That's why I got denied, because of Amin Osiris's lack of understanding about law, right? So they're telling you here what you need to come with as far as the words that you use in your initial complaint. Now, here's my legal argument against the DCSS. I would like to state for this court that my previous filings, let me explain before I read this. So DCSS hired a private firm to handle this case for them. So that's their attorney. So they look back at the paperwork from the trial court, from the county court, and they got all that paperwork, right? Now, this is in an attempt to say that, he's a state court loser. He's just mad that he lost in state court and he's trying to take it federal. Well, res judicata and the Rooker-Feldman doctrine says you can't get federal relief if you've already lost in the state court. You can't do that, right? And that is true. You cannot do that, right? According to the Rooker-Feldman doctrine. And they're saying that I tried to do this before and I lost, right? But look at my argument and what I'm saying here. It's very important to read between the lines of what I'm saying here. So, legal argument. I would like to state for this court that my previous filings in the Federal District Court of California was rejected because I did not state a claim upon which the court can grant relief 2 times. This is Amin Osiris's scam right here. You know, he's not helping you with stating a claim, right? So I understand that now. So better just to be truthful about it in this case. So the court did not reject my motions to move jurisdiction because I was a state court loser. So that's because they're saying that I'm trying to get into federal court simply because I'm a state court loser, which the Rooker-Feldman doctrine will bar me from doing that. But I'm saying that I'm not a state court loser because, well, I'm saying I'm saying I lost because I didn't state a claim on which is a very important distinction to make here, right? And I said, as I will prove, res judicata cannot be utilized as legal settling to dismiss this case because a final decision and judgment cannot be made by a commissioner, right? So res judicata is saying that a decision was made that you can't go to the federal court also, right? And I'll do a quick Google search to see what res judicata is in my mind because I don't know it word for word, right? So I'm saying that res judicata cannot be utilized because a commissioner cannot make a judgment, right? You in California, you need a D204 form, and we'll get into that also. So res judicata can only be applied to cases where a final judgment has been made by a judge within a court of competent jurisdiction. I would also like to state that defendant's counsel said plaintiff then twice moved to set aside the judgment. Correction, I only moved once to set aside judgment. Commissioner cannot give judgment because the parties never stipulated for her to do so, right? So let's read on. This court possesses lawful jurisdiction because they're trying to say that the federal court doesn't have jurisdiction. So the defendant's counsel is using Walden 571 U.S. to determine whether a forum state may assert specific jurisdiction over a non-resident defendant. Focuses on the relationship among the defendant, the forum, and the litigation. Now, I understand the forum to be the state in which someone is trying to reach a litigant for whatever purpose. So California, the DCSS California is trying to reach across into Arizona, which already means that they cross state lines, that the federal court has jurisdiction. That says it in the Constitution, right? And the forum is what you're touching. So they're touching the forum state, which is Arizona, and they're trying to get to me, right? So by mailing me letters saying I owe money and threats and things like that. Defendant is attempting to use a three-part test to determine if minimum contacts has his court jurisdiction over the case, right? This minimum contacts. A lot of business law deals with minimum contacts. One, the non-resident defendant must purposefully direct his activities or consummate some transaction with the forum or resident thereof. So they're directing their activities toward me, right, in the state of Arizona, and they think that there's some kind of obligation or contract in which I have to pay. But there's no obligation or contract if you look beyond prima facie, right? Or perform some act by which he purposely avails himself of the privileges of conducting activities in the forum, thereby invoking the benefits and protection of his laws, right? So they want to execute their law of this obligation in the state of Arizona, but they're also susceptible to federal jurisdiction as they do this, and you'll see my response here. They are still mailing demands for so-called child support, back payments for over 7 years now, crossing state lines in pursuit of this goal. Crossing state lines enters into federal jurisdiction. This purposeful availment dictates that the state did directly reach over state lines to collect the so-called debt, in which I have the right to dispute, right? I do have the right to dispute that. Must purposely direct his activities or consummate some transaction with the forum, which they did, right? Because they're trying to reach me through it. They think there's some kind of transaction that needs to be made because of some debt, right? So that would be number one. They touch, that's one minimal contact. And then two, the claim must be one which arises out of or relates to the defendant's forum related activities, right? So what is the defendant's forum related activities? The rule exists to protect people from being forced to travel to a distant state to fight a lawsuit unless their specific bad actions in that state cause the problem. The relatedness from the actions of the county DCSS did cause a legal injury to myself because of gross negligence and violations of federal rules of court procedure they chose not to follow, though they signed a contract with the federal government swearing an oath to do so. So The claim must be one which arises out of a relate. So, the claim must be one which arises out of or relates to defendant's form-related activities. So my claim is, since they never made a decision on my case, I never stipulated, signed a DO-204 form to do this. My claim coming out of these form-related activities is that I've been injured, right? I've been harassed, uh, and all that because I'm suffering because of these people. You know what I mean? So the relatedness from the actions of the DCSS did cause a legal injury to myself because of gross negligence and violations of federal rules of court procedure they chose not to follow, though they signed a contract with the federal government swearing an oath to do so. So the Rooker-Feldman doctrine cannot be used here because of the actions of the DCSS and their deliberate attempts to collect on a non-obligated debt, which did cause me suffering, which comport to two parts a three-part test, right? Which satisfies. I could have put satisfies, but I put comport. Next part. The court should disregard defendants' submitted documents because counsel lacks personal knowledge. Now, this is something I got from the brother Yusef L. long time ago on Right Knowledge Radio. I'm not Right Knowledge Radio, but High Frequency Radio. He talked about when he went to court. So you got to talk about for people who actually went to court, and won their case. We're brave enough, we're bold enough to go in there with the knowledge that they had through, studying for years and then going in, and applying what they know. So he said he went to court, and there was an attorney that wasn't part of the original case. So Yusuf L objected. He said objective. Defendant or plaintiff's counsel lacks veracity to attest to the documents that he's submitting into the court. I just remembered. I was like, wow, you can do that. I said, okay. So I stuck that in my mental note for a long time now, and I used it here, right? Because they hired a private firm to represent DCSS, but the private firm went back and got all the trial court documents and submitted them into this case. And I knew that was a mistake of what they tried to do. They're trying to deceive the court and then say, oh, he did this before. He's just trying to, this is just revenge, and there's really no suffering here. And, he's just mad because he lost the case in 2016 or 15. And I'm saying, I don't have a problem with the decision. I have a problem with the procedure in which the outcome was based off of, right? So it's all about procedure. So let's read what I wrote here. In their motion, defendant's counsel attempts to attest to the veracity and accuracy of documents regarding plaintiff's prior courtroom proceedings, talking about myself. However, counsel admits, or the record reflects, that counsel was not present in the courtroom when plaintiff pleaded their case. Counsel could not attest to the veracity of the submitted documents because counsel was not present in the courtroom when I pleaded my case. Under Federal Rule of Civil Procedure 56C4 and similar state rules, any statement or declaration used to support a motion must be made on personal knowledge, right? They're a third party. They have no personal knowledge. They were not there. An attorney cannot simply attach a document from a completely different court case and claim it is perfectly accurate and true if they weren't there to witness it. In legal terms, the lawyer lacks a foundation to authenticate the document. Under well-established procedure rules, an attorney's arguments are not evidence because counsel lacks personal knowledge of what actually occurred in that courtroom. They cannot properly authenticate these documents or swear to their veracity. Therefore, this court should disregard these unauthenticated documents and deny defendant's motion, right? Then we get into the Rooker-Feldman doctrine. Actually, let me do a quick, I'm not going to share my screen about it. I'm going to res judicata. Like, what is the meaning of res judicata? Res judicata meaning, right? So it says res judicata is a Latin phrase meaning a matter judged. It is a legal rule that stops people from filing the same lawsuit or claim over and over again after the court has already made a final decision. So without having any knowledge of uh, this person, this child support commissioner, knowing that she could not make a legal ruling, res judicata, the private firm, thought this was going to be an open and shut case. I can tell you that. They didn't really take me seriously, and they don't take you seriously. They think that you're dumb. They don't think you're going to do deep research and look between the lines. But I know they were going to put in a motion to dismiss because that's just what they do. It's procedure. And I knew they're going to use the Rooker-Feldman doctrine, right? I knew it, you know. So res judicata just says, hey, if this case has been judged before, you can't keep bringing the same case. Can't keep doing it. Unfortunately, for the defendant's attorney, they don't know that I know that a commissioner cannot make a judgment, right? So res judicata doesn't apply because there's never any judgment on my case, right? So now we're going to look into the Rooker-Feldman doctrine should not bar this case, right? That the court does have jurisdiction to hear this case. The Rooker-Feldman doctrine does not bar this action because plaintiff alleges an independent constitutional injury under 42 USC 1983. People are very familiar with this because a lot of people on the internet use it. And it's basically when government officials go beyond their power, police, basically people representing the state. So let's read. The Rooker-Feldman doctrine does not bar this action because the underlying state child support order is completely void on its face, right? A commissioner cannot make a judgment. Under California Family Code, subsection 4251, a court commissioner has absolutely no power to enter a final judgment without a stipulation from both parties. This is where the D204 form comes from, right? Because I never stipulated, the commissioner acted entirely without jurisdiction. She had no personal jurisdiction over it, right? Making her order a complete nullity from its inception that cannot trigger a federal jurisdictional bar, right? Counsel also says that I am a state court loser, since counsel has no idea what's going on here and is merely filling in the holes to make an argument that will sway the court. I'm letting them know they're trying to manipulate the court, right? They're trying to deceive the court. Counsel in court must understand that Title 4D is not a court of record. Many things that were said in court, the defendant's counsel would have no idea how it impacts this litigation. I have full knowledge of what was said, offered, denied, ignored, pleaded, and what was not just written on a piece of paper in favor of Title 4D, court, of course. Defendants' reliance on Rooker-Feldman doctrine must fail, as the Supreme Court held in ExxonMobil Court versus Saudi Basic Industry Corporation. Rooker-Feldman does not bar federal jurisdiction over independent civil rights claims, right? So that's what 42 USC 1983 is. Furthermore, under the Ninth Circuit law in Moor versus County of Trinity and Coahugacion versus TMSL Incorporated, the doctrine is incapable where state actors use deceptive, unauthorized conduct. And that's what I'm saying that this Penny K. McLaughlin did. You know, she knows she's not a judge. She knows her title, and she knows the limitations and the parameters around her title, though she chose to step out of that. And once she stepped out of that box, limiting her power, she's susceptible to this lawsuit here, right? Such an omitting mandatory statutory due process notices to strip a citizen of their rights because the underlying order was signed by an unauthorized commissioner lacking a stipulation under California Family Code subsection 4251. It is void on its face and holds zero preclusive effect under Knoll versus Hall. Commissioner McLaughlin and DCSS had a chance to hear my pleadings. When asked for proof of how I was served, she chose to stay silent when she had an obligation to answer my lawful questions. Her actions were more of an enforcer than of a judge surrogate. It is well established that for her to act as judge when she was a commissioner, she could have offered to present both litigants with a D-204 form. Under federal law, the court must rule that Commissioner Penny K. McLaughlin's judgment is legally void under Federal Rule of Civil Procedure 60b-4 if the rendering court lacked subject matter jurisdiction, personal jurisdiction, or acted in a way inconsistent with due process. Because non-Article 3 officials do not possess inherent judicial power under the U.S. Constitution, their authority to issue a final binding judgment depends entirely on statutory limits and party consent. Right. So they're not Article 3. They're not a justice, right? They are simply a judicial officer dressed up in a robe to deceive the average litigant. And under that deception, she's assuming you're too stupid to know that she cannot rule on your case. And she wants that power, so she exercised it. So it's up to people like me and you and my students to enforce law, right? And enforcement means going to court, appealing this in the state court. You do need to exhaust your state remedy if you're living in that state. In my case, I moved, so that's why I went to the federal court of competent jurisdiction. All right. Another point defendant's counsel has made is that this is some type of revenge from December 1st, 2015. My claim here is not being a sore loser or arguing with the outcome or adjudication by the judge surrogate or child support hearing officer, nor commissioner. My complaint is against the absence of procedure on how they came to that decision. Counsel has either misread my original complaint or is willful choosing not to answer my complaints point for point. In the defendant's statement, they try to frame the issue as plaintiff claims direct challenge the validity of the December 1st, 2015 judgment in the state court action, establishing plaintiff's paternity of a minor child and ordering plaintiffs to make child support payments. Again, counsel fails to understand that this is based on procedure, not a judgment by a commissioner. Counsel lacks merit and fails to see the damage that was caused by a commissioner or judge surrogate, right? Because this was in their motion to dismiss. So I used it as a point that they really don't understand what's happening because they lack personal knowledge. They cannot attest to the veracity and accuracy of those documents. They're guessing. At best, they're guessing. They're trying to infer. It's an estimate. It's not something that somebody would say if they bear witness to something or the procedure of the case, right? So let's go on. Family Code Section 5246B is taken out of context because it is based off a legal judgment and not a void order. The argument that local child support agency 5246B allows the local child support agency to bypass a judge and send a garnishment order straight to an employer is true. I come to find out this is true. However, counsel failed to state a parent might argue they were denied due process if the LSA failed to serve them properly. And that was my original complaint from day one. I was not served properly, so I couldn't go to the initial hearing, right? So I said, as I said in my initial complaint, I was not able to attend the December 1st, 2015 hearing because I had no knowledge of the legal action taken against me. DCSS knew I was going to fight the case, so they decided to use sewer service. And sewer service is where they're putting in paperwork as if they served you, but they didn't. So they can just move along with the case. It's a legal procedure, basically. It's an illegal procedure. It's strictly illegal. But child support will do this if they know you're going to fight it. You know, so I would not appear in court to fight the case so they can win by default. In addition, this argument presumes that the previous actions taken by the commissioner were followed by state procedure, and which must follow. What am I saying here? In addition, this argument assumes. I'm sorry, there was a fly in here. I was trying to swat it. In addition, this argument presumes that the previous actions taken by the commissioner were followed by state procedure that was lawful. I have already explained that the commissioner cannot pass judgment without a D2 or 4 form. California Code of Civil Procedure, Section 259D. So the legal machinery was not followed in order to give the right output for justice. She did not follow California Constitution, Article 6, subsection 21. Right? So I think it's pretty clear California also is against what she did. Defendant's res judicata argument fails because the commissioner's order is not a final judgment by a court of competent jurisdiction. To invoke res judicata, the defendant must prove that a final judgment on the merits were entered by a court of competent jurisdiction. Defendant Penny K. McLaughlin fails to satisfy this burden. The order referenced by defendant was issued by a court commissioner, not a judge. Under applicable law, a commissioner is a subordinate judicial officer who lacks the authority to enter a final binding judgment unless the parties explicitly stipulate to their jurisdiction. Plaintiff did not stipulate to the commissioner's final authority. Because the commissioner's order was entered without a stipulation, it lacks the binding authority of a final judicial judgment. Additionally, as noted previously, defendant's counsel was absent from the courtroom and lacks the personal knowledge required to authenticate any purported stipulation or finality. Because there is no final judgment by a court of competent jurisdiction, res judicata cannot apply. Plus, there was no procedure followed to determine if I was the biological father of the child or not. If such procedure took place, I would ask the court to let counsel show the court how the procedure was performed and who performed the DNA test. But where is the sworn testament that I gave to make myself the legal father? Where is my signature on birth certificate? Is it good enough to just have my name summons me to court and automatically extort my earnings simply because of the will of the state? So I'm asking counsel to the defendant's attorney's counsel to answer these questions because they were not performed, right? They weren't performed. Federal rule of civil procedure exists to prevent states from extorting their own citizens and violating civil rights, which states do all the time, guys. They do it all, not even just child support. If they think you're stupid, they're going to take you to court and squeeze all the money out of your estate, right? And put you into slavery. So Yickwo versus Hopkins in 1886. Yickwo is a Chinese immigrant in California who worked on I think he worked on the railroad, right? So peace to Yickwo. He's probably a lot of Caucasians violated his, because of racism and hatred, right? So I really enjoy using this case law. Established that legal procedures and government rules violate the 14th Amendment's Equal Protection Clause if they are applied with a discriminatory purpose or an evil eye in unequal hand, even if the law appears neutral on its face. Well, it's not that the law appears neutral on its face, it's how it's applied or omitted to violate your civil rights, right? So the ruling prohibits arbitrary enforcement by officials and dictates that judicial procedures must apply equal to all persons regardless of citizenship status. At the time, Heidi Parrott was a DCSS attorney when I appeared in court. See, I didn't appear in court, so I'm gonna see if I can amend this and make this correction. When I appeared in court in December 1st, 2015, and I still find it amazing that she won the case and never said one word in court, right? Because their attorneys don't say anything. The court commissioner or judge surrogate does the enforcing for the child support services. So, like I said, this has been going on for 11 years and more. If you want to check out all the docket sheet in my case, you can look up this case number here, right? Now I am educating another one of my students to file their own paperwork, and I'm pretty proud of this individual. He's from California. I'm not going to say their name here, but California has this new process where, hold on, I'm trying to bring up this. They have a new process, and it seems to me the process seems to violate um, uh, testimony and evidence. I'm not going to get deep into it, but I kind of feel like it's another roadblock to freedom. So we're gonna. Ah, man, they're not letting me share my screen. Hold on. I think closing one of those will get it. Stop presenting. Ah, come on. Wonder why share my PDF. I'll just share my whole screen. Okay, so here, I was telling my client, my student client that because I don't write the affidavits, I teach you how to write the affidavits, right? Because this is education for educational purposes only. So when we go over his case, I'll tell him to look up certain case laws and child support, um, and I'll educate them in a couple of short courses about what's happening. How these courts are bloodsuckers of the poor. They think you're stupid, and they're going in there just to rape your estate, right? Because everybody breaks bread, right? Even the attorney that you hired to modify your child support is also getting paid from the state. So you paying them, but they get paid double, right? So California has woken up to the fact that a lot more people are trying to file appeals for their child support illegal procedure courts, Title 4D courts. So what's happening is they're actually taking testimony from the court and the commissioner and from you. So it's called a settled statement. I just realized this because of my student, in California. So I started to take a look and study a little bit. And, I was, in this case, it's kind of weird because his baby's mother would put him on child support, take him on child support, put him back. These emotional female demons are, of course, they're going to use anything to get to you and try to ruin your life, right? This obsession they have with some of their babies' fathers, I know because I went through it and I'm still going through it on the personal note. They can't get over the men that got them pregnant. They're so in love with them that they hate them. It's a thin line between love and hate. And so she's opening cases, closed. She's misusing the court system for revenge, the Title 4D court. So the court on their settled statement, they lied. Of course, they lied. They said that, oh, we let them know that she's going to judge the case, and even if she did, California law still stipulates that you need to be presented with a D204 form, and it needs to be on record that you offered it to both parties. They didn't do that. They said it after the fact that that he brought it up, right? And then he put it in the paper and so on and so forth, right? I was telling them that, you should probably put that as a part of your legal argument, look up the case law, or look up the rule, the civil procedure rule, and mention that. So this is what my student came up with. I'm proud of him. He's learning how to use legal language and Black Laws Dictionary and learn from other people too on the internet, So this is titled Objection to Court's Proposed Settlement Statement, right? So court with Judge Surrogate and local child support agency have made operational errors in the fact that, one, old case 976, request for dismissal 11/7/2019, in any order based on commissioner's ruling is void ab initio. Court admits that it cannot prove that I was advised that court commissioner has a need to act as judge since no D204 form was issued to both parties. right? Because they're lying and saying, "Oh, we let them know," but they can't prove that they let them know. They can't prove it because at the inception of the case, of this case, they never put it on record. See, this is where you catch them, y'all. You catch them here because once you get educated and you find out that you're being defrauded by the court, you still have 1 year to put in your paperwork. From the day that you found out you're defrauded, you have a year. And then you can go back and say, hey, I was defrauded. If the court commissioner needs to act, then she needs to ask both parties and we need to agree to it. She never did that. Two, in case number, because this is when the baby mom was going back and forth, putting them off child support, and maybe when she liked what he did, took him off, and then she didn't like what he did, put him back on. It's crazy. These women are crazy, right? So two, in case number ending in 1266, I requested that court set aside default judgment March 4th, 2026, because I was never served as proven by the process server's affidavit, where it states that the process server visited my mother's house, where in fact I did not live there. So the court never got the proper address of where my student lived. So the process server that they paid to go by there put in their affidavit, I couldn't reach him. So you have not been legally served if that's not your place of residence, right? So legally, I was not served because the papers were never handed to me physically by a process server. The case should have been dropped without legal notice to defend it myself, right? So I don't know what's going on, right? And you keep opening up cases, closing them. So I'm thinking it's dismissed, right? Well, my client saying, I think it's dismissed. Three, the settlement statement by the court lacks merit because when the court says contact was made as early as 2019, this is referring to a case that was already dismissed and is not relevant to the new summons and complaint yielded by the LCSA. New case number is de novo and lacks any legal link to the old case number, right? Diana Torres is using for I'm sorry, I guess her name is Diana Torres is using the family court system as a tool for revenge, filing multiple child support cases for emotional reasons. This is heavily penalized under California Family Code Section 271. In response and reply, marriage of Thorpe. She is using the LCSA as her own enforcement arm. 5. Court is mistaken that it finds I had full knowledge of child support obligations. I never said that I did not know about child support case against me. I did say in court by my own research and my volition that I discovered that a commissioner cannot act as judge. Under Family Code Section 2122 Alpha, I have 1 year for the discovery of the fraud to legally file motions against any fraudulent parties that have injured me. The time gap is worthy because I discovered this fraud on February 4th, 2026. I filed motion to set aside default judgment on March 4th, 2026 based on my new legal discovery, right? So this document here is in response to what they said, right? Now, I want to show you another affidavit that my student filed. Let's see. But let me see. Okay, well, his name is here. I don't want to put his name out there. I don't know if I can redact on this. Pretty sure if you find the court case number is here, so you can look it up. It's public record, but I don't want to put my students' name out there. I don't know how to. Oh, here it is. Here. Oh, okay, I see how to do it. I got it. Okay, I got it. So give me a second. I gotta look that real quick. I want to read this to you guys. Now, when the student came to me seeking advice, okay, there's his name one more time. So, student came to me seeking advice, you know, put him in the knowledge program. See, because it's all about defending yourself. You can't look for me to defend you all the time. So I put him, I figure out what the situation is first, right? We figure out what the situation is first, and then I may not be able to help him, to help him with his case. So I don't want to assume, right? Um, so we figure out what's going on. Ah, okay. I have to edit the video. Okay. So now we're looking at my student's case, right? What's going on? So this is the case number. This is not the appellant case number, but we are appealing illegal procedures and what's going on here. So in defense of constitutional rights and acknowledgement of violations of state and federal procedures, this is what we labeled it. And it's in Fresno County. So comes now my student and the proper person to address the wrongs that have been willfully enacted against my free will. Right. And the reason I told him he should write something in the lower court, because like I said before, if you file an appeal, the appellate court is going to look at the trial court's records. They're going to look at the docket. And if what they see all comes from the trial court, it's going to make you look very bad. That's why you need to file your own affidavits in the lower court, so the lower court can see that you've been arguing this case, because you can't start your legal argument in the appellate court. They'll throw it out. You have to file something in the trial court. So I made contact with child support in 2019 to state that I did not participate in any undertakings with the child support agency, that I am not an obligor through any written or implied contract. Though this case was dismissed, 976, child support customer Diana Torres has some type of vengeance against myself and has misused the Title 4D services and hired the help of the child support agencies to open up 2 different cases against myself, misusing the program at the whim of her will and harming my person with an attempt of extortion. Child support lacks any legal merit in this case of private property or chicanery. The minute order for DCSS case number 711, consolidated case 957 on date 4/20/26. The child support attorney states that I willingly paid the amount stated, but failed to mention that these were wage assignments and garnishments made through the color of law, and the illusion of a proper procedure, which involves California Procedural Law 259D, which restricts court commissioner on various duties, but explicitly refrains them from acting as temporary judge without consent of both parties. That includes a signature of the D204 form, which Commissioner Judge Surrogate Noel Pabet failed to disclose. California Procedure Law of Title 4D services must be linked with the federal Title 4D procedure law, which states voluntary acknowledgement, simple civil process. Procedures for simple civil process for voluntary acknowledging paternity under the state must provide that before a mother and pituitary father can sign an acknowledgement of paternity, the mother and pituitary father must be given notice orally or through the use of video or audio equipment and in writing of the alternatives to the legal consequences of and the rights, including if one parent is a minor, any rights afforded due to minority status and responsibilities that arise from signing the acknowledgement. Note that this minute order, the court recognizes as part of the case that I reject and object to any findings made without my consent, implied or written. The tantamount doctrine states, the doctrine requires that the party or the attorney was actually aware the judicial officer is a commissioner, not a judge. If a party is unaware or not informed, participation does not imply consent, because the California will try to use this too. They'll try to say, well, you never said anything and you paid. A garnishment is not a willful payment, especially if it's by a commissioner. And they'll try to say, well, you acted as if you agreed to the contract, like an unwritten contract that you're acting in accordance to, But uh, if the judge, as we said in the objection to settled statement, if the party's unaware, not informed, you never informed me, so how am I supposed to know? Participation does not imply consent because you're participating under fraud, and the law protects you from that. Minute order dated 12/12/2025 explicitly states that Noelle Pabet is a commissioner. However, the minute order on 4/20/2026, it states that she is a judge. How did this happen without a signed D-204 form or proof on the case docket that she had been a judge from the start of the case? She's lying. They're lying, right? That's why you keep all the paperwork from child support, guys. Keep it all, right? Everything they send you, even if it seems like it's not in your favor at that point, trust me. You come to my class and we'll educate you and open your eyes, and you'll see that they're telling on themselves. They have to, right? In addition, I never received a summons about any legal actions against me at the physical address in which I resided. The plaintiffs admit that they mailed my mother, where I did not stay at the time, and never obtained the proper address in which I was staying at this time. So in essence, under the law, I was never served. Therefore, no legal action can be taken should have been against me. You got to put me under California Law of Civil Procedure, Title 14, Chapter 5, 1013 Alpha. So they think just because his mother is there that he visits his mother every day, but unless he told the court this is where I stay and never got an update on where he actually stays and receives mail, just because it's his mother doesn't mean he's been legally served, right? So don't assume that. In case of service by mail, the notice or other paper shall be deposited in the post office, mailbox, sub-post office, substation, or mail chute, or other like facility regularly maintained by the United States Post Office in a sealed envelope with postage paid, addressed to the person on whom it is to be served at the office address as last given by that person on any document filed in the cause and served on the party making service by mail, otherwise at that party's place of residence. Service is complete at the time of the deposit, but any period of notice and any right or duty to do any act or make any response within any period or on a date certain after service of the document, which time period or date is prescribed by statute or rule of court, shall be extended 5 calendar days upon service by mail if the place of address and the place of mailing is within the state of California, 10 calendar days if either the place of mailing or the place of address is outside the state of California but within the United States, 12 calendar days if place of address is the Secretary of State's address confidentiality program, and 20 calendar days if either the place of mailing or the place of address is outside the United States. But the extension shall not apply to extend the time for filing notice of intention to move for a new trial, notice of intention to move to vacate judgment pursuant to Section 663A, or notice of appeal. This extension applies in the absence of a specific exception provided for by this section